Okay, we'll go ahead and get started. We have a lot to get to today. Hi, everyone. Thank you so much for joining us, and welcome to the Environmental Law Institute's webinar, Existing U.S. Federal Authorities to Address Plastic Pollution. My name is Sarah Viken, and I'm the Manager of Educational Programs here at ELI. For those of you who may not be familiar, ELI is a nonprofit, nonpartisan research, publication, and education organization that works both domestically and internationally on the most pressing environmental issues facing our world, including plastic pollution. And I'm now realizing I forgot to share the slides. So we're going to do that super quick. There we go. We have a great program lined up for you today following a recent report of the same name that we published with the Monterey Bay Aquarium. We'll put the link to the report in the chat, as well as the link to the event webpage with the slides, with complete speaker bios and materials for today's webinar. We'll also try to post the relevant materials here as they're mentioned. If you're unable to stay for the entire program, a recording will also be posted to that same event webpage within a few business days. I want to take a moment to thank our speakers, Cecilia, Margaret, Mary Ellen, and James, who you may recognize from leading ELI's monthly PFAS briefings, for being here with us today. We will be taking audience questions following everyone's presentations. So if you have any questions, please submit those at any time throughout the program using Zoom's Q&A function. You can find that at the bottom of the screen with the chat and all of those buttons. This will just help Cecilia see them and sort through them if we have an active chat. So we do encourage you to use the chat for observations, resources, and comments, but we will be pulling all discussion questions from that Q&A box. Now, before we get started, I want to introduce our wonderful moderator. Leading today's discussion will be Cecilia. Cecilia Diedrich. Cecilia is a staff attorney at the Environmental Law Institute, where she leads the plastics program and manages projects related to the advancement of nature-based resilient solutions within the Mississippi River Basin, tribal consultation policies, and hard rock mining regulations. Before joining ELI in 2023, she was a litigator and policy advocate at Defenders of Wildlife, where she worked on wildlife habitat conservation issues. Cecilia is a co-author of the ELI and Monterey Bay Aquarium report we will be looking at today, titled Existing U.S. Federal Authorities to Address Plastic Pollution, a Synopsis for Decision Makers. She also represented ELI at the last round of global plastics treaty negotiations and has presented on plastics in multiple venues since joining ELI. Thank you so much, Cecilia, for facilitating today's program. And with that, I'll turn it over to you to get us started.
Thank you so much, Sarah. And thank you everyone for being here with us today. As Sarah mentioned, ELI and the Monterey Bay Aquarium recently published a report on existing U.S. authorities to address plastic pollution. This webinar is a continuation of that work and will cover aspects of the report and much more. We have honestly a stellar panel for you today. Each will give a presentation, which will be followed by a question and answer session, as Sarah said. First, we'll hear from Margaret Spring, who will share her insight on the plastic pollution crisis and the need for domestic action. Margaret is the Chief Conservation and Science Officer at the Monterey Bay Aquarium and an ELI board member. She joined the aquarium in 2013 to oversee its many conservation and science initiatives. Prior to joining the aquarium, she held leadership roles at the National Oceanic and Atmospheric Administration during the Obama administration and the Nature Conservancy, as well as served as senior and then general counsel to the Senate Committee on Commerce, Science, and Transportation. Among her many appointments, she chaired the Congressionally-mandated 2022 National Academies report, Reckoning with the U.S. Role in Global Ocean Plastic Waste, which honestly, this report was a lot of the impetus for the ELI Aquarium Authorities report that brings us here today. And Margaret is also a co-author of that report. She currently represents the Monterey Bay Aquarium and the International Science Council at the Global Plastics Treaty negotiations and helped form the National Academies Roundtable on Plastics. I will follow Margaret with a brief overview of our report and then turn the reins over to Mary Ellen Turnus and James Pollock, who will share their expertise with us on several areas of plastics and toxics regulation. Brief overview of both of their accolades. Mary Ellen is a partner at Earth and Water Law. She has long been recognized nationally in the fields of chemical engineering and environmental law and advocacy. Her practice brings over 30 years of in-depth experience at the intersection of energy, manufacturing, air quality, hazardous waste management, infrastructure, and disaster response. Her knowledge and experience made her an invaluable contributor to the ELI Aquarium report. Prior to her work as an environmental attorney, Mary Ellen began her career at the US EPA, working with her Vanderbilt University degree in chemical engineering and Superfund emergency response as an on-scene coordinator, then hazardous waste site remediation and permitting, transitioned to industry as a commercial hazardous waste incineration compliance manager, and then back to US EPA as a law clerk for the EPA's Office of General Counsel. Both a fellow and past president of the American College of Environmental Lawyers, as well as a fellow and leader within the American Institute of Chemical Engineers, she contributed to the 2022 National Academies Reckoning Report as well, and has represented the Global Council for Science and Environment at the Global Plastics Treaty Negotiations, as well as is the lead editor of the Spring 2024 National ABA National Resources and Environment issue entirely devoted to plastics, and serves as an expert on the National Academies Roundtable on Plastics. Since 2019, she has been a regular fixture in the plastic discussion space, and shares her expertise on plastics across the country, and we're so glad to have her here today. James Pollock is a senior associate at Martin Law. He leads the firm's consumer products regulatory practice. He helps consumer product manufacturers in the apparel, footwear, outdoor gear, and food products industries who are working to understand the complicated and shifting regulatory and litigation environments surrounding emerging contaminants. He has extensive knowledge on PFAS regulatory compliance at the federal and state level. He also counsels clients on chemicals management, how to make effective green marketing claims, Proposition 65, and other compliance issues. Prior to joining Martin Law, he clerked for Chief Judge Brian M. Morris at the U.S. District Court for the District of Montana. He is also the author of the recently published PFAS Dust Book and has shared his expertise on PFAS and other chemical issues and numerous presentations in recent years. And I wanted also to say, before we go into the presentation, we know that the Supreme Court has been issuing large decisions as of late, particularly overturning Chevron last Friday in the Loper-Bright decision. Like you, we're still digesting a lot of this information, but Mary Ellen has kindly incorporated some coverage of this into her presentation, and there might be other opportunity for discussion of this during the question and answer portion of this presentation. I also wanted to point you in the direction ELI has been following this and preparing for this. And so if you have interest in reading more, we have a report titled The Supreme Court, Environmental Regulation and the Regulatory Environment, which addresses the case in sections 3 and 4. This will be posted in the chat and can be found on our website. So beyond all of that, I just wanted to say a quick thank you to all our panelists for being here today. And with no further ado, let's hear from Margaret Spring.
Good morning, good afternoon. Pleasure to be here. For those of you who may not be aware of plastic pollution, of which I hope there is none, I will do a quick overview of what we know, because we have done a number of scientific studies, and we'll go over one of those today. Since synthetic plastic was first developed in the early 20th century, production has grown exponentially. In 1950, the world produced just 2 million metric tons of plastic per year. By 2019, annual global use reached 460 million metric tons, and that amount is expected to nearly triple by 2060. Every year, it's estimated that 19 to 23 million metric tons of this plastic leaks into the aquatic environment alone, including lakes, rivers, and our ocean, hence the interest of the Monterey Bay Aquarium in this topic. Today, the petroleum and varied chemical composition of most plastics, as well as plastic waste, is causing detrimental impacts to the climate, the environment, wildlife, and ecosystems, as well as human health. In short, along with use and production, plastic pollution and its negative impacts have grown exponentially. Whole and broken down plastics are readily seen on our streets and in our waterways, but they have also permeated the deepest parts of our ocean, the air above our tallest mountains, the food we eat, and our own body. Next. So, in support of addressing this global problem and pursuant to congressional mandate and the bipartisan Save Our Seas 2.0 Act of 2020, NOAA, the federal agency, sponsored the Ocean Studies Board of the National Academies of Sciences, Engineering, and Medicine to commence a study on the U.S.'s contribution to global ocean plastic waste and recommend potential means to reduce those contributions. So this was the first scientific synthesis. It's very important. It's probably and since then, there hasn't been another like this. So for now, this is sort of the state of knowledge of the U.S. role. And at the close of 2021, we issued this report confirming the nation's outsized role in global plastic pollution, and recommended the United States adopt a plan of action by the end of 2022. We recommended a life cycle intervention approach and a national strategy, a science and policy strategy, because we found that there was no comprehensive approach taken yet by the United States, and unlike other countries or even states. So next slide. So what did this report say? Well, as I said, it stressed there should be a comprehensive strategy across the plastic life cycle, and what we have depicted here is what we call the plastic life cycle. Many of us have only experienced the plastic at the 5 and 6 end of the spectrum, but really the beginning of plastic pollution starts with plastic production and the way plastics are designed. What we found in our report was that while the United States had taken steps probably in the 4, 5, and 6 categories, very little had been done at the 1, 2, and 3. And so in order to have an effective strategy, there had to be an emphasis for action at all stages, and an emphasis particularly in what we call the upstream activities. At the same time that this report was being developed, a number of studies have been coming out, and you're seeing this in the news still today, but a number of comprehensive studies have been coming out also speaking about the human health impacts, which we did not cover because it was not in our scope, but also and the fact that there are chemicals in plastic that also pose harms, and you're going to hear a little bit more about that. Simultaneously, while those studies were coming out, including from the United Nations, the global plastic pollution and crisis and its impact on human health and the environment prompted governments across the world to start formal negotiations for a United Nations treaty to end plastic pollution. And following the release of our report, the U.S. formally joined those negotiations and now working with nations worldwide to identify and address the problems associated with pollution, both internationally and domestically. So next slide. So one of the things we did in this report, as we laid out all the needs and the gaps, was saying, well, what do we have in our arsenal? And so Appendix C, that nobody read, of the report, tried to lay out where our existing authorities were and tried to piece this together. Why we embarked upon this new report was to start fleshing out. We basically wanted to ground our report in this National Academies study because it was the most comprehensive to date of the United States, and then start looking more deeply into what the legal authorities might be to support U.S. action. It was particularly geared to identify the pathways the United States can take to meet its stated goal, both domestically and in the Global Plastics Treaty, to, quote, eliminate the release of plastic into the environment by 2040, and to, quote, protect human health and the environment. So those are the two very ambitious statements of ambition for the United States, and we thought that this would be an important contribution. So the report is intended to be a useful tool in the process of shaping a U.S. all-of-government approach to addressing plastic pollution, including legislation and positions being developed on Capitol Hill, a stakeholder understanding of the potential regulatory landscape. Third, policies and priorities established by individual agencies, such as the EPA when they issued their draft plastic strategy. Fourth, the Interagency Policy Committee discussions on a domestic science and policy strategy as called for by the National Academies, and the resulting evolution of the U.S. position at the Global Plastics Treaty. And so I also, going to the next slide, I also want to say that outside of the federal domain, which this report really covers the federal domain, corporate reputational, fiscal, and liability risks, as well as state and local policies and lawsuits, are actively shaping the landscape and may accelerate pressure towards clearer national and global rules and requirements. So we don't cover that in this report, but I just wanted to flag that as federal action is only one piece of the bigger puzzle, and we're seeing daily new challenges to the way we're addressing plastic pollution. So what's in this report, which Cecilia is going to lay out? It's just the existing U.S. federal authorities across each intervention. We have it organized in a way, so if you just are interested in what EPA can do or what FDA can do, we lay them out there. If you're interested in what all the agencies can do under each intervention area, that's laid out that way too. So it's intended to show pathways, help people get their minds around what we've seen. It also recognizes the actions to date of the federal government at the time of our publication, which was March, which was the creation of this Interagency Policy Committee on Plastics in a Circular Economy within CEQ at the White House, all the environmental justice and sustainability executive orders that have come out, the draft national strategy from EPA, as I mentioned, and there are a number of rulemakings and agency actions that were underway, either previewed or already issued. So while it's comprehensive, it's not exhaustive because there's a lot of information that we would love to incorporate into a second version of this. So, and it doesn't identify a timeline for federal action. This is intended to be a guide, and it doesn't, as I said, evaluate state action because that was way beyond the pale. So what I would like to say to this large group is that our feedback on this report is welcome. If you have some thoughts or questions, please send them to us in the Q&A, and we'd love to incorporate some new insights into our next iteration later in the year. Thank you very much, and I'm going to turn it over now to Cecilia to go over to the report itself.
Thank you so much. And Sarah, just so you know, I'm going to say next slide because I lost the app that I had before to be able to do that. So as Margaret was saying and so well kind of summarized, this report grew out of the National Academies report. She said no one read, you know, Appendix C, but we did a lot. And building upon that, it was really important to kind of develop this base layer of trying to identify what tools the U.S. government had at its disposal to start to address plastic pollution. We view this report as a step one, but as Margaret said, there are lots of opportunities for further development of regulations, new legislation on the table, I mean, continually being developed. States are taking action. There's litigation underway. There's a lot happening in this space, not to mention all of the evolving scientific information and monitoring improvements in this space. So it's a complicated area. This report is robust, but we tried to make it as user-friendly as possible, thereby making it easy to look at bits and pieces of it as they're relevant to you and what you're most interested in. And so the infographic on this page, this is just a summary of what I'm going to be going over. The infographic is intended to illustrate the life cycle of plastics and where each intervention may be applied. Again, you know, the scope and complexity of this problem and the interventions and strategies in this space go well beyond what we proposed here and what the NASEM report identified. And so there will be opportunities to go beyond this and build upon these themes. But talking about plastic pollution in this way and solutions is important for both, you know, continuity within the U.S. government approach and also the global plastics treaty approach to this problem. Next slide, please. There we go. So what we're calling, you know, intervention one, the first intervention area. And as Margaret said, these are the areas where we're, I don't want to say lacking, but there needs to be more focus in these spaces earlier on in the plastic life cycle. So regulation of production and associated pollution, and then restriction of problematic and unnecessary polymers and chemicals of concern is an important component to all of this. As of now, a lot of the, you know, authorities that we identified are relevant to emissions from the production process and not necessarily go to, you know, the actual regulation of plastic production on the front end, though there are plenty of opportunities to do that. I've listed some of the primary statutes underneath each of these sections. I'll go over a couple of them, but a lot of these will be covered more in depth by Mary Ellen and James in their presentations. So the Clean Air Act is an incredibly interesting opportunity to regulate in this space, as is TSCA and the Clean Water Act. And, you know, focusing more on the facility side, there's also the National Environmental Policy Act. Mary Ellen's an expert in the Clean Air Act and the Clean Water Act, and James can speak to TSCA a bit more. So I'll leave those portions of the presentation to them. Next slide, please. Next, early on in the production stages is also the innovation of material and product design through enforceable product standards, voluntary commitments, and standards for labeling and marketing. So a lot of this gets to the voluntary actions that can be taken and or existing regulations about the products themselves. There's also a lot of opportunity for R&D in this space, and so we wanted to highlight those things. Next slide, please. Then we move on to decrease waste generation through product bans, mandatory procurement rules, extended producer responsibility. Again, TSCA can play into this space, but there are also executive orders that are relevant to this, and especially as the government is such a large purchaser, implementing procurement practices that reduce demand in the space is really important. Next slide, please. Improvement of waste management through disposal, collection, and recycling improvements, as well as water treatment improvements and monitoring and data collection requirements. Again, RCRA is an important element in this space, and the Clean Water Act. There are specific programs that could be, are already doing work in this space and or could be expanded to address plastics more specifically. Next slide, please. Capturing waste by removing plastic from waterways, wildlife, and habitats and hotspots. This is a really, really broad category, but again, we're getting to the back end of how to regulate plastics within the life cycle. This is where, the Clean Water Act comes into play. And then, there are marine specific statutes where we can do direct removal of debris from the sea, as well as using our technological resources. NASA has some really interesting satellite technology for hotspotting. So really using anything and everything at our disposal to try and remove the plastic waste from that is removable from our environment at this point in time is incredibly important. Next slide, please. Minimizing at sea disposal. So again, before even capturing waste, figuring out ways where we can minimize the actual pollution on the front end. We have authorities under a lot of our marine statutes to be able to regulate this and really do more enforcing on this end. So this is an interesting and exciting space where further development could be beneficial. And then the final space, please. So we added this. It was somewhat incorporated into the NASEM report, and we kind of added this as an additional intervention space where information and data collection, research and development, and outreach and education will be pivotal to to supporting all of the strategies under the specific intervention areas. And so utilizing the United States' robust resources in this space is incredibly important and something that the government has a lot of authority to move on. And next slide, please. So our main takeaways from the report, and Margaret summarized these to an extent, is that the federal government has the authority to start to address plastic pollution at every single stage of the life cycle. Increased funding and legislative support could help, support faster, more robust action. And as I was just saying, information and data collection, R&D, are imperative to us being able to move forward on all of these. And then next slide, please. And if you are interested in accessing our report, it's available, in the link that you were provided, but also on ELI's website and the Monterey Bay Aquarium website. And I will turn this over to Mary Ellen, who's going to talk more about some of the specific issue areas that I did a brief overview of.
Thank you, Cecilia. And Sarah, I'm happy for you to continue to advance, if that's all right. You go to the next slide, please. So it's a very busy slide. There are lots of words. First bullet basically says, why are we here? Answering the question, why are we here? If you take a history lesson, you go back to way back when I graduated from college, 1984, and I began working for EPA, Superfund program. It was clear to me as an on-scene coordinator, the OSCs are the ones who go out to situations like the East Palestine train derailment, and their commanders on the scene. You have to deal with the chemicals that you've got. In remediating many different sites and working within the Superfund program, it became very clear to me. We developed all our analytical techniques and our risk assessment and our categorization of different ways based upon a set of industry products and byproducts that were generated during the 1960s and 70s when we first came up with these statutes that we adopted to protect our air and our water, media-specific protection from industrial pollutants. We focused on acute risks from ignitable, corrosive, reactive, and toxic solid waste. And we implemented them relying on this known chemical inventory, developing, again, these responsive techniques that were designed to support the implementation of those statutes at the time. If you want to take a quick look at the Emergency Planning Community Right to Know list of lists, it's very interesting to see exactly how all the pollutants fit within, all the different statutes and how, they are regulated in each media. But many pollutants didn't fit our perception of risk. For example, persistent chemicals like PFAS, and we've been playing catch up. Well, plastic didn't fit either due to its inert nature. You can see, by design, it's intended to be perpetual in existence. We design it and manufacture it to be tough. And so, because it is inert, it is solid waste, not hazardous waste. But as we know now, it is this same feature, this thing that we work so hard to manufacture, this feature of inert nature that causes it to be persistent, so persistent that it never actually breaks down. Well, it does, but not meaningfully for our purposes, does not degrade. Microfractures, fractures into tiny little microparticles that can bioaccumulate and pose other unique risks that we haven't actually completely characterized and integrated into United States environmental policy. So we have plastic and its degradation products, micro and macro nanoplastic pollution, which is the inevitable result of unrestrained production, use, waste management, leakage in the environment, which poses their own unique risks. We've got plastic particle exposure, bioaccumulation, biological interference from particles, ingestion, inhalation, and dermal absorption. We also have chemical exposure to the plastic additives and adsorbed chemicals in the environment or in the manufacturing context that are adsorbed onto the particle through releases from the plastic. These chemicals that are either in the plastic added intentionally, unintentionally, or adsorbed to the surface are released from the plastic particle surface at increasing rates with decreasing particle size. So the smaller, the faster the rate, because the more of the volume is exposed to the environment on the plastic particle surface. It's the faster rate is released to the environment, small particles, and into organisms where particles act as chemical delivery devices through inhalation, ingestion, and absorption. Another feature that we have to recognize is that this plastic is something that microorganisms love. So there's also the risk of pathogenic exposure to microorganisms that thrive on plastic surfaces, including micro and nanoplastic surfaces. One of the questions I typically get is that how are we just now thinking about these microplastic particles as a threat? How come we didn't ever pick up on this? And if you look at the initial risk assessments done years ago, the risk assessments on microplastic were done using microspheres, the kind that were added to personal care products. And microspheres don't have the same features as some of these microfractured secondary particles. They tend to sort of roll right out of the biological organism, whereas and at the size tested, such that the microplastic particles we find in the environment are not represented by these microspheres from earlier testing. The types of smaller and smaller problematic sharp-ended shards and curly fibers are not just eliminated, and they can bioaccumulate and been shown to interfere with biological processes. So we haven't been looking for these particles until recently. Our environmental sampling and analytical techniques have been developed now. Were historically developed just for this perception of hazard that we grew up with. But now we are developing new methods to try to characterize these particles and the chemical risk and the particle risk. Next slide, please. So just as an example of a few different statutory opportunities, OSHA, for example, it has the general duty clause where each employer shall furnish to each of his employees employment and a place of employment which are free from recognized hazards. So specific standards. Well, OSHA does have rules for particles, carbon nanotubes and fibers, silica, asbestos, and talc. OSHA has recognized isocyanate exposure during manufacture of some plastic products. And then the National Institute of Occupational Safety and Health, NIOSH, I think I got the acronym right, Nanotechnology Research Center is studying exposure from releases of airborne nano and microplastics, particularly thermal degradation products of polytetrafluoroethylene that can result in polymer fume fever and potentially fatal pulmonary edema. NIOSH is looking at developing approaches to measure, assess, and mitigate nano and microplastic exposure in the workplace and recommends voluntary control measures. So when we think about that, we understand OSHA and NIOSH, they're in the process. We know that we have standards. And the point about particulate matter, which I'm going to get into just in a moment with the Clean Air Act, is we have been regulating particles primarily under the environmental statutes as a mass per volume basis, or milligrams per cubic meter. So I'm going to mention just the asbestos for a moment. The permissible exposure limit for an 8-hour period for asbestos particulates size 0.1 to 10 microns, which is 100 to 10,000 nanometers, this is a standard, 0.1 fiber per cubic centimeter. So given what we're seeing with the micro nanoparticle research with NIOSH, we may end up with a similar count per unit volume limit for microplastic exposure. We don't know yet. But some scientists have expressed concern when referencing asbestos along with microplastic, given that asbestos has a smoking gun of mesothelioma, which we don't have yet for nano and microplastic. We don't have it yet. But historically, our social experiment with microplastic posing both particle and chemical risks might in some cases be more like asbestos wrapped up in PFAS than the early microsphere research, because they're quite different. The microproducts we have now, saturated in chemicals, are quite different than the research limited to that simple microsphere stuff. So consider the asbestos timeline. We began making ships for the war effort in the 1920s and 30s using asbestos insulation, asbestos in the manufacture and production of the ships. Asbestos was a great flame retardant. We began making everything out of asbestos, from insulation to cigarette filters and Christmas tree flocking to the snow in the Wizard of Oz. But then in 1964, the Journal of American Medical Association published its research, Asbestos Exposure and Neoplasia, associating the shipbuilders' exposure with fatalities and incidents of disease, including mesothelioma. That's about 30 to 40 years between the significant exposure and the broad recognition of harm. Consider also the PFAS timeline. James is going to talk about PFAS, but the PFAS timeline is also interesting. Commercial production of PFAS beginning in the 1950s and really taking off in the 1970s until Rob Bilott filed suit against DuPont in 1999 based on the evidence demonstrating harm. And 20 years later, we're finally regulating it. We have anticipated period of time between the recognition of harm and the point in time when we're going to regulate it. Litigation collapses that time frame often. What we see with PFAS, what we saw with asbestos when that came out, there was litigation immediately. And I think that we're starting to see litigation with plastic. But from the 1960s, when plastic was a new market, if you remember, everybody says to me, plastics from the graduate. Yeah, when that was a new market in the 1960s, to now, when exposure to plastic is unavoidable in our daily lives, we have to ask, are we the shipbuilders of today in our own living rooms? That's the question. We don't know. But exposure in our homes has been shown to be higher than exposure outside. Every week, we see new data published that establishes the presence of micro and nanoplastic everywhere on the planet, as Margaret said, including everywhere in our food, our water, our agricultural fields, our consumer products, and our bodies, and suggesting associations with blood clots, cardiovascular disease, and plaque formation, pulmonary inflammation, infertility, dementia, and congenital malformation, and more. So we don't know. It's a grand social experiment. Next slide, please. With the Clean Air Act regulates particulate matter sources reviewed that EPA considers in its PM 2.5 implementation. EPA has a list of sources, and if you look at the header on this slide that I can't see because it's behind the you are viewing ELI development, but I know I point to the page on the report in the footnote. In the footnoted reference, you'll see a little bit more detail. I did review EPA's list of sources that it considers in particulate matter to weigh its risk, and microplastic isn't included. It's of course not counted in the PM 2.5 measurement. The PM 2.5 ambient air quality standard is a mass per unit basis. There's a 24-hour and a annual standard. But these filters capture the mass of PM 2.5 that is drawn into the high volume sampler, and that filter is simply weighed. So the particles aren't counted. And the smallest particle is about 1 micron. So that's, 1,000 nanometers. So, it's not speciated, and the limit is not as low as you'd think, 1 to 2.5 microns. The EPA is looking at this, looking at PM 2.5 and looking at microplastic and nanoplastic. But what I can say now is that we have sources of known sources of nanoplastic and microplastic emissions. For example, municipal waste incinerators burn plastic. They're allowed to emit PM 2.5 at a rate of 25 milligrams per meter cubed, up to 100 tons per year or more is permitted without speciating for microplastic. In the stack emissions, the fugitive emissions, the ash content of the wastewater discharges, and there's no plastic destruction efficiency required to be demonstrated. Fugitive level emissions, being not from a stack, but just from the crushing of plastic and in solid waste management, plastic recycling facilities, is also, to my knowledge, not regulated in terms of micro and nanoplastic particles. Microplastic fibers that preferentially concentrate in wastewater treatment plant sludge are then land applied as biosolids, only to be released as fugitive ground level emissions through wind erosion. That's not permitted or tracked. And then, of course, there's tire wear particles. The Clean Air Act regulates tailpipe emissions, not tire wear particles, and the mitigation measures have to do with fleet fuel efficiency standards. Again, not tire wear particles, and that's important because heavier cars create more tire wear, and electric cars are heavier. So, we haven't designed our systems, our waste management systems, to deal with plastic. As a former RCRA hazardous waste incinerator permit writer, one of the jobs I had after I left Superfund, and as a compliance officer for a commercial hazardous waste incineration company, I worked to permit and demonstrate complete destruction of hazardous waste to the 99.9999 destruction removal efficiency standard, 6.9% DRE. Working along with the chemical engineers designing and permitting and patenting these units, we designed and operated the units to specifically destroy the waste fed to them, whether it was PCBs, polychlorinated biphenyls, dioxin waste, or later, my legal work, chemical weapons. We haven't designed municipal waste incinerators to completely destroy plastic. We don't have permit requirements that that impose operating restrictions that would improve the destruction of plastic. We don't test for remaining microplastic in air emissions, water discharges, or ash, and we ignore ground level fugitive emissions from waste management and deposition, just like we ignore it from tire wear particles. Next slide, please. Now, I think EPA has discretion to regulate microplastic. So, if you recall the Chevron deference and, the Loper decision, well, Chevron was a Clean Air Act case. It was about how EPA was going to interpret and implement the term source, whether it's a plant-wide or a bubble emissions counted for the term source. And it wasn't spelled out. The statute was silent. And the judges in that case, this is where Chevron came from, where the statute was silent and doesn't contemplate separating out different sources within a plant site for Clean Air Act regulatory purposes. The judge said, well, the judges are not experts in the field, and the court found EPA was entitled to deference. But if you think about Chevron later, in Massachusetts versus EPA, the court chose not to defer to Chevron. The court decided that the Clean Air Act's broad and an unambiguous definition of air pollutant had to include greenhouse gases, because the definition said any pollutant, agent, or combination of agents, including any physical, chemical, biological, radioactive substance or matter which is emitted into or otherwise enters the ambient air. Well, that's pretty clear. It's just anything that's emitted to the air. In Lip or Bright, I think air pollutant's pretty clear. Particulate matter is pretty clear. The one thing that we struggle with, of course, is the method by which we would measure it. But I think there's opportunity for EPA to regulate microplastic and nanoplastic under the ambient air quality standards or under as a hazardous air pollutant. Next slide, please. I will say, can you back up, Sarah, one slide? Because I did mean to say, because it's just too good to leave it alone. In his dissent in Massachusetts versus EPA, Justice Scalia said, everything airborne from frisbees to flatulent qualifies as an air pollutant. So noting here, frisbees are in fact made of plastic. The court's already said the definition of air pollutant is clear. So there you go. I think it regulates microplastic. I think EPA has the authority absent Chevron to go ahead and regulate it as either particulate matter or HAP. Next slide, please. Thank you. Another possible opportunity would be under the Solid Waste Disposal Act, which was amended by the Ricker amendments, but the original act prior to Ricker still had the open dumping and plastic hotspot. It had open dumping prohibition. And look at 355 and the resource cited there. If you open that up, you can read a little bit more about it. But the open dump is any facility or site where solid waste is disposed of, which is not a sanitary landfill, which meets this criteria under the statute. Open dumps are prohibited. That's, many years ago, at the beginning of the regulatory programs, states were delegated with the authority to implement these provisions of the Solid Waste Disposal Act, and EPA said, look, you all got open dumps. We need to renovate those and go from open dump to sanitary landfill, and then finally to municipal solid waste landfills. But EPA has always maintained that open dumps are prohibited, that states are required to list them under a solid waste management plan and then clean them up, right? And EPA, even though it's old, you think, well, EPA, that happened one time only. Well, EPA still raised this in its 2015 coal ash regulation, saying that new open dumps are prohibited. Now, regarding remediation of these open dumps or plastic hotspots, because they're all over the country. We've seen them in New York with the New York Attorney General case versus PepsiCo filed November 15th, PepsiCo and Frito-Lay. It details how the AG's office sorted the trash collected along the Buffalo River and identified PepsiCo and Frito-Lay as the sources of the majority of the trash, and seeking not just cost of remediation, but also disgorgement of profits. Then on June 20, 2024, Baltimore filed suit against PepsiCo, Frito-Lay, Coca-Cola, and plastic manufacturing companies to recover cost of their plastic waste management. So this is ongoing. EPA doesn't need to create a list prohibiting open dumping, but it is prohibited, and the states and it looks like cities are actually taking action to recover their costs to manage them. But I think this is something EPA could enforce, and it's something the states and cities can enforce. Take a look at the Plastic Litigation Tracker Center online to monitor the litigation, and look at the Center for International Environmental Law report released last week, Making Polluters Pay. Plastic Polluters Pay, how cities and states can recoup the rising cost of plastic pollution, discuss various legal strategies. Next slide, please. So this is a really big slide. It's very complicated, but I love this graphic. Margaret is a co-author on the Minderu-Monaco report, and I think it was really helpful in pulling everything together. So I encourage you, take a step back and think about plastic in our planet now, where our planet is saturated. Considering the entire, I say life cycle, every time I say life cycle, people tend to think that once you dispose of it, it's no longer life cycle. Plastic doesn't die is the problem. It's always alive because it doesn't die. It fractures and becomes more problematic, but it doesn't die. So the entire cycle of plastic production, product use, post-use plastic, and microplastic fate and transport, and its failure to meaningfully degrade in the context of U.S. environmental law as both a particle and a chemical. And consider the data showing that plastic is now everywhere on the planet, and just about everywhere in us, we're saturated with plastic. And then consider the study that was released in Science Advances on April 24th, Global Producer Responsibility for Plastic Pollution, basically finding that For every kilogram of plastic produced, it results in a kilogram of pollution. We are so saturated, it has nowhere to go. That's that report, April 24, Science Advances. The challenge with plastic as a pollutant is that it risks are both particle and chemical, as well as other properties, and we have yet to characterize the electrochemical and physicochemical properties. And the particles, chemicals, and other properties vary as much as the polymers and chemicals used in manufacturing and the sizes and shapes resulting from continued fracturing during use, post-use management, environmental fate, transport. It can seem overwhelming. I understand it's overwhelming. And people say, well, how in the world can we figure out the risk? Well, but we've done it in the past. We have prioritized, we figured out what's not a problem. Apparently microspheres are not a problem, right? We have other shapes and sizes that are much more problematic. We can prioritize and aggregate risk for regulatory purposes, as we have in the past for grouping pollutants. For example, we calculate dioxin risk not per each molecule. We boil it down to the equivalence of 2,3,7,8 tetrachloride dibenzopyrdioxin, because that's the most toxic form of dioxin. We say the dioxin risk for this site is X number TCDD equivalents. We can do this. We can prioritize and figure out what's a problem, and we can figure out a strategy to deal with what seems to be the most problematic and prioritizing that way. Next slide, please. And in mitigating micro and nanoplastic pollution, there are new tools. If we cannot just read the label like New York is doing and Baltimore is doing, where they pick up the trash and read the label, forensic experts with over 50 years of Superfund litigation experience fingerprinting groundwater plume data are eager to fingerprint both the microplastic particles and their unique and proprietary chemical additives to identify the source, with developing analytical and evidentiary approaches. So look at particles. Recall, we discussed how particles have been regulated as mass based on filter catch, not by particle count or characteristics of the particle, like asbestos would be regulated by particle count. But we are developing new techniques. If you take a look at the first bullet on the orange, the second bullet there in the orange slide, you see the Environmental Council of States and Environmental Research Institute of the States Interstate Regulatory Technology Council, or ITRC, has a microplastic project. With that, the states are cataloging their microplastic sampling analytical methods. So take a look there at the new methods for microplastic monitoring, particularly their page on biosolids application was very interesting. And then look at January 8th, which is very interesting. We learned that we don't just have 400 microplastic particles in our bottled water in each bottle of water. We have about 400,000. And each liter, 90% of that is nanoparticles. We learned that in January. And I'm quoting from the article now. They used a new hyperspectral stimulated Raman scattering, SRS, stimulated Raman scattering, imaging platform with an automated plastic identification algorithm that allows micro nanoparticles analysis at the single particle level with high chemical specificity and throughput measuring below 100 nanometers. That's amazing. So now it looks like we have some new technology for the particles. And then on the chemical side, you've seen how chemical identification has been difficult with 16,000 different unique proprietary additives. Well, we are working with that, but they are marketed that way. They're not that different. Just as an example, they fall into families. So there may be 2,700 phenolic antioxidants in the market, but many reflect a basic functional chemical structure repeated throughout. It's not as complex as it appears. And we believe 16,000 can be greatly simplified for regulatory purposes. Now, the tough part about chemical analysis, though, is that generally, if you've been doing environmental work for a while, you understand you almost need to know what you expect to find and analyze for that, not just sample something and then determine what in the world it's in. It's not like asking a question. You sort of need to know what you're analyzing for. But now looks like we have a new technology that utilizes AI and computer algorithms to develop a completely identified spectrograph of the chemicals that are analyzed by the machine, so that it's not so much guesswork. You can have the computer figure out what the peaks are and isolate them. So advances like these will assist in fingerprinting unique chemical additives associated with microplastic pollution in the environment to identify the source, if you can't read the label. Next slide, please. Last slide, and as a segue to James Pollitt, our next speaker on PFAS, with all the PFAS risk assessment, regulation, and mitigation, it's important to note that PFAS may be part or may constitute itself microplastic, fluoropolymers, for example, such that microplastic may be mitigated with the PFAS mitigation. and that PFAS removed through these measures may also be or may contain microplastic. And risks of these together, PFAS and microplastic, might be magnified. So if we have PFAS on secondary microplastics, well, what we find is in the environment, PFAS, it adsorbs, it clings to the surface of these secondary microplastics. Microplastics play a role as carriers of harmful chemicals absorbed into our bloodstream, meaning we soak in the microplastic and then it delivers that dose of the PFAS and other chemicals into our bodies, where otherwise it might be eliminated. It's left with the microparticle that's in our bodies. And that nanoplastics, we don't have to actually inhale them or eat them. They actually can be absorbed through our skin. So with that fun note, James, I'm going to leave it to you. Thank you.
Thank you so much. So much to take away from that presentation, and really appreciate the detail and even diving into the science there. Really fascinating stuff. My role here is to talk a little bit about the PFAS, the way that different regulators have been targeting PFAS, and lessons that we can learn from sort of the PFAS experience thus far in understanding what an approach to plastics might look like going forward. Let's go ahead and jump forward. So to start us off, I know this isn't explicitly branded as a discussion about PFAS, so I'm going to try not to assume too much knowledge, but I will say that this is a pretty popular topic right now, so I wouldn't be surprised if folks are at least somewhat familiar with PFAS. They're synthetic, meaning human-made. They're highly mobile and persistent chemicals. As Mary Ellen was referring to, these synergies or these similarities with plastics are pretty obvious on their face. What's also interesting about them is they're defined as a family of chemicals, and depending on the definitions that you use, you'll get a very different set of counts for PFAS. So you might hear estimates of 1,500 chemicals that are in the economy. You might see 9,000 chemicals. You might see 13,000 chemicals or 15,000 chemicals. The reason for these different estimates are the use of different definitions. And these definitions really matter for what is encompassed within the family of chemicals. There's actually a standards committee set up by ASTM to look at the regulation of PFAS in consumer products that for the last, I think, 2 years now has only been discussing the definition of PFAS. So you can see that the definition really does make a difference here. There are sort of general categories, especially if you look historically at PFAS, including C8 or long chain, referring to the carbon backbone of the structure, or shorter chain like C6 or C4 or even smaller, as well as polymers. You can use PFAS to construct polymers, membranes and things like that, that have all kinds of consumer and industrial applications. There are really valuable qualities to PFAS, including oil stain, grease, and water repellency simultaneous, which is a pretty unique feature of these chemicals. They're non-reactive and stable. They decrease friction, heat resistance, durability. And as a result, we see them used in a number of different places, both for consumers as well as in industry. You'll see them used as surfactants, used as grease, used for surfaces, for heating. There are any number of potential uses, including potentially rain jackets and things. This is a really interesting piece on the right here, this chart. This is a little bit of a dated family tree, but it shows the number of peer-reviewed articles per PFAS chemical. And you'll see there are clusters of research focused on particular chemicals. And this is going to be a theme that I'll go back to. But what's interesting is the way that science progresses, especially in dose exposure studies or understanding the effects of chemicals on people or mice or any number of organisms. You focus in on a chemical. And you can only focus in on one or a few chemicals at a time if you're trying to disentangle their effects. So this shows the focus on particular chemicals by peer-reviewed article. And you'll see there's a lot of research done on historical PFAS like PFOS or PFOA. And then for some of the newer PFAS or PFAS that are shorter chain, there's less research, and that has implications in the regulatory sphere. Let's go ahead to the next slide. And PFAS in the environment, our understanding continues to grow on a weekly basis. But those same chemical properties of PFAS that make it so useful in industrial and consumer product applications also help it spread and accumulate. It moves through the environment, it cycles through the environment, and it can bioaccumulate in exactly the same ways that we've been discussing with plastics. It's spread by water and air, and research shows several different potential human exposure pathways that we experience through our lives. Everything from drinking water to food, occupational hazards, the use of PFAS within the workplace, dust, air particles. And I was even seeing research in the last week studying dermal exposure. Dermal exposure there's been research for a little while now in certain applications, like in firefighting context with high heat, but we're starting to get other research on dermal application or dermal exposure pathways for humans as well. So our understanding of the effects of PFAS on humans continues to grow over time. Let's go ahead to the next slide. Yeah. So as I was asked to prepare for this with my knowledge of working in PFAS, I started to see a lot of parallels between PFAS and plastic. And I wanted to sort of bucket a few of those challenges and thoughts to provide sort of a framework here for the discussion. I think one of the challenges here is definitions. Both plastic as well as PFAS are defined by a group of chemicals with similar characteristics, similar chemistry, similar functions. But the fact of this sort of grouping or family creates challenges within our traditional environmental law frameworks. A lot of our environmental laws are designed to focus on chemicals on a chemical by chemical basis as opposed to a family approach. There are caveats to that, and there are interesting ways that folks can innovate the approach to chemistry, but that is something that has to be thought about. And an example in the PFAS context is PFOA versus PFAS as the family. And so you'll see, for instance, with Superfund designation, there's designation of a subset of PFAS, not all PFAS, but that can still be useful. And I'll talk a little bit more about that in a minute. The breadth of uses for this chemistry. For PFAS, there are these consumer product applications, things ranging from ski wax to jackets to food contact surfaces, industrial processes. And as a result, PFAS waste is generated by a number of different categories. It's not something you can just focus in on one sector and say, we've got our hands on the PFAS problem. It turns out it has implications far beyond any particular segment of the market. And that means you have to look at a broader set of generation of PFAS, the use of PFAS, as well as waste containing PFAS that will implicate not only hazardous waste disposal, but also more traditional landfill disposal, which, as research has shown, is becoming a major source of PFAS contamination. We see exactly that same challenge with the plastic problem, where plastic is used in a number of different sectors. And so you can't just focus on one. Scientific knowledge. We see the quick generation of scientific knowledge on fate and transport, as well as the way that different media will spread or contain the contaminant. And that development of knowledge will change the way that we think about regulating those chemistries. And we see development on testing, which can lead to new ways to ultimately regulate what we're trying to get at, as well as the research is showing discovery of the breadth of impact. It feels like on a monthly basis, I see research finding PFAS in new places, ranging from the base camp of Mount Everest to polar bear brains. The impact of that research is to show the way that PFAS move through the environment so readily. And it means that we have to think through new ways of regulating these chemicals. The international scope of the problem, I think, also aligns these two families. The international component of manufacturing, use, and waste disposal. We can't ignore other countries when we approach this problem. Our oceans link the entire world, but also our supply chains link the entire world. And so understanding the ways that waste moves, products move, is going to be essential to getting at this. And we've certainly seen that within the context of recycling in recent years. And then finally, multimedia implications. It's not just with some traditional pollutants, you might just focus on groundwater, or you might just focus on soil, or you might just focus on air. But the challenge with this chemistry is that it has implications across a variety of media. When something like this can be readily taken up by biological material, it means that you have implications on fishing, you have implications on deer hunting, you have implications on the redevelopment of a property all the way to your industrial waste permit. So the implications of this cover all of environmental law as a whole. And the multimedia impacts of this are reflected in our scientific findings, what I was discussing earlier. Let's go ahead to the next slide. Now, we've seen a lot of activity on PFAS, and this is an entirely reductive slide that tries to get at a few of the categories that I think are worth thinking about. And each of these could merit its own discussion. At the federal level, we have seen a number of different environmental laws being applied to PFAS. And I think something that's really useful is the administration put out a PFAS roadmap. This roadmap has been updated several times. It's worth taking a look at because this roadmap actually sets out the, quote, whole of government approach to PFAS. This isn't just going to be a targeted focus of EPA alone or one agency taking on this chemistry. It's actually going to be the whole of government. How do we think through each of these different laws and how they interact with this chemistry? So we see the traditional environmental laws being utilized to regulate PFAS at the production stage. So chemical production and use regulations in the form of TSCA, pre-manufacture notice. This is a critical form of regulation that's been utilized by several administrations to target especially legacy PFAS, the use and potential reintroduction of those PFAS into the economy. We have seen reporting regulations, the requirements to report PFAS, whether in products or articles, and that's TSCA. Congress actually adopted a new reporting framework under the Toxic Substances Control Act, requiring reporting of the use of PFAS in articles imported into the United States between 2011 and 2022. It's going to create an entirely rich data set of the uses of PFAS across the economy and what types of PFAS have been used across the economy. But similar reporting regulations have also been adopted under the Safe Drinking Water Act, which has collected the most comprehensive data set of PFAS contamination in drinking water supplies we've ever had. Under UCMR 3, the Unregulated Contaminant Monitoring Rule 3 as well as 5. Both of those focused on PFAS in our drinking water supplies and required that drinking water suppliers search for and report PFAS in drinking water. Under EPCRA, this is a law that doesn't come into a lot of folks' practices, but requires reporting on the use of chemistry in manufacturing processes in the United States and allows folks to prepare for emergency response at the local and state levels. EPCRA is now being used in a very focused way to show where PFAS is being used in manufacturing. CERCLA also has its own reporting requirements, similar to EPCRA, and they largely overlap. And then we have the Clean Water Act, which we were talking about just before this presentation started, about ways that discharge permits can be used to monitor discharging of PFAS into water systems. The way that EPA has been starting to implement its general reporting or its general permits, and you can take a look at, I'm forgetting the region, but Massachusetts region, I think it's Region 1 actually, EPA Region 1 general permit has really interesting information about monitoring PFAS in wastewater systems. It's worth taking a look at. We have media regulations under the Clean Water Act and the Clean Air Act, exposure prevention regulations in the form of the Safe Drinking Water Act, preventing PFAS in drinking water, waste and cleanup regulations under RCRA and CERCLA. And then, of course, with the whole of government approach, we have all this EPA work, but what about all these other agencies? Like the Consumer Product Safety Commission, which has indicated an interest in potentially regulating consumer products containing PFAS, or the FDA's reconsideration of PFAS in food contact surfaces and working with industry to phase out PFAS in food contact surfaces, as well as DoD looking at the use of PFAS in its military equipment. That's just the federal side. On the state side, we have entirely new regulations going into effect, as well as traditional forms of regulation. Things like Prop 65, which provides warnings to consumers about chemical content in their products, which we've seen early indications may be used to target microplastics as well. OEHA is currently taking a look at that. And so we could see developments in the same way that we see these developments in PFAS, developments in plastics. We see new consumer product regulation that's going into effect, like bans on the use of PFAS as a family in certain product categories, reporting frameworks requiring reporting of PFAS in these products, incorporation of PFAS into standards for permits, and disposal regulations entirely independent of the federal government's authority, as well as purchase limitations, saying that fire departments can't purchase things containing PFAS, or that consumers can't purchase things containing PFAS. These are really interesting mechanisms and I've seen a lot of questions in the Q&A about Loper Bright. These kinds of state activities will continue whether or not Chevron doctrine is a factor, because states have their own regulatory authority, and when a state like California acts, it can have huge implications across the international market. Let's go ahead to the next slide. So what kind of lessons can we learn from all of these efforts in the PFAS space? I've gone through a lot of them, and if you want to go into detail, I recommend taking a look at the PFAS desk book, which does a good job of laying out a lot of these efforts. Data collection is a critical first step. If you can't measure it, you can't manage it. And so understanding at the production phase, the introduction into the economy phase, the use phase, all the way into the disposal phase, everything that Cecilia was laying out there, each of those steps is an opportunity for data collection. And there are all kinds of mechanisms in place already that can be utilized to collect that data. Identification of common indicators or proxies can be a useful tool. While PFAS testing on a chemical by chemical basis is costly and especially difficult if you start looking at different media or uses beyond water. It's hard, for instance, to test for PFAS on a metal. Those kinds of test methods are really expensive, not generally accepted. But if you can search for a proxy like organic fluorine or fluorine, that gives you at least an idea of what's potentially in your sample. And similarly with plastic, if you can use proxies, if you can search for things that indicate plastic, that can be a useful indicator and a useful tool for regulators. Existing authorities also provide a really robust toolkit for regulation across the chemicals life cycle. I think we've seen creativity in the PFAS experience And taking a look at that model shows the flexibility of this toolkit to collect data, to regulate chemicals, as well as shows the opportunities for new laws as well. You can go ahead to the next slide, although I think that might be my last one. It was. I think I pass it to you, Cecilia.
Yes, thank you so much, James. That was wonderful. And to Mary Ellen and Margaret as well. It was, I mean, I think everybody can tell this is such a knowledgeable group and people who are really ingrained in this space. So I want to take an opportunity to get to some questions here with our remaining 20 minutes. The first question is more general, and we've gotten this a lot regarding our report, kind of given the complexity of the plastic pollution problem and our existing regulatory framework, are there opportunities, or where do you see opportunities for immediate action and or priority areas for action that the federal government can take?
Well, I'll just start us off, but so our report lays out a few. Certainly, we just heard from James and Mary Ellen. There are a lot of low-hanging fruit areas. Certainly, the PFAS example tells you that there's a pathway and there's a roadmap. However, so just the definition of pollutant under the Clean Water Act. It's definitely a concern. I've seen some questions about the Corps of Engineers Rivers and Harbors Act. Certainly, plastic, it can be seen as a pollutant or a discharge of a fill. There are lots of ways you can use existing authorities, to your point, to address the introduction into the environment, which is a major issue. However, there's also ways of addressing, driving the procurement decisions of the United States towards less harmful chemical containing products. We're waiting to see the Federal Trade Commission come out with their green guide. That will really, and that's an independent agency, so I'm not sure that we know exactly when that's coming out, but those guidances that will steer people's decisions are going to be very important and probably are quicker than some of these regulatory pathways. Certainly, we're particularly concerned about the chemicals at the treaty level. Production reduction is incredibly important, and all the pollutants that come from there, and also the additives and the concerns defense line communities are actually being discussed and acted on to some extent in the federal government, but not fast enough, and there's a lot more to be done. And then we have the concerns about effluent limitations. There are all sorts of, there's so many ways. I think the problem is that we have not treated it as a pollutant, which it is. And if you keep producing more plastic, the nanoplastics and the microplastics are going to get bigger. So you really have to go to the top of the chain to really start to address this issue. And the faster we can do it, the better. But I'll turn it over to my learned colleagues who have much more to say.
I can mention, James, I'm gonna sort of pitch this to you as well. But after Rob Bellot filed his landmark case against DuPont, there were government study groups to actually get their arms around PFAS, and we haven't done that I've seen with microplastic. Why not? Why aren't we? We have methods to analyze it now. We can't. I mean, EPA is not going to be able, as a former EPA employee, I mean, we can't just say, oh, that's regulated now, and we don't have a method yet. We need to study it. We need to figure it out. We need to prioritize. Until we do that, we don't really have a good answer. It seems as though we've been working at cross purposes. We said, oh, too much plastic, let's recycle. Well, that's not working. I mean, it's trouble. You're looking at the questions and answers. One of the questions is, well, doesn't this mean maybe we shouldn't be recycling plastic? It's really tough. Our thought was, I think generally the principles were, if we recycle and reuse it, we won't make as much. But that doesn't really work. It's not working out that way. And the recycling processes themselves, if they're not regulated properly, create more pollution. They're just more manufacturing plants. And the fact is these plastic particles aren't being regulated at all. If these technologies are exported to less developed countries, then that's a problem. It almost has a perverse incentive to ship more waste to them, and then they can't manage it properly because they just don't have the resources to do that. So it's recycling is tough. as Margaret said, putting a cap on production is what the world is talking about, but we're not good at that in the United States. What happens in the United States, and James, you can speak to this too, is, as we saw with PFAS, we kind of tend to trail litigation, right? We find these hazards that aren't defined, and we rely on plaintiffs' attorneys often to drive the regulatory hammer. So James, I'll turn it to you.
The only piece that I think I would add to that is also one opportunity for low-hanging fruit is to find where folks are focusing on this problem and then use those opportunities creatively. And I think what you're describing is there are opportunities for plaintiffs to focus on these things, and then that builds momentum. There are potential opportunities elsewhere as well. There's currently this development of packaging EPR, extended producer responsibility regulations throughout the country, getting at essentially this packaging, the development of packaging as this huge source of pollution that needs to be dealt with. And plastic is a huge component of that. We're going to be seeing the development of pretty large data sets about the plastic packaging inputs, single-use packaging inputs into our economy at the state level across the country, as well as there are going to be these entities set up, these PROs, producer responsibility organizations, that are going to be dealing with the recycling of that material, funding research, funding that recycling. There are opportunities here to look at that problem and use those opportunities to ultimately address plastic. So I think it's worth thinking about where is work already, as far as low-hanging fruit goes, like where is work already being done that aligns, and where are there opportunities to be commenting, to be activating on those issues to build momentum ultimately at the federal level.
Thank you. And thanks to our panelists for incorporating answers to some of the other chat questions into their answers on this front. We do have a lot of questions, and it is nice to kind of touch as much as we can in a limited time. So one question that we've gotten a lot concerns the Loper-Bright decision and kind of where the agency kind of stands with, the potential of not getting the deference that they've gotten in the litigation space up to this point. Mary Ellen talked about this a bit with respect to the Clean Air Act, but does anyone want to try to address this a bit more, just in the plastic space in general?
I can just mention quickly. Chevron was, spent a whole lot of hours briefing time on Chevron over the past 30 years. But in the end, a court, as we've heard discussed, the courts will take a look at the agency decision and determine whether they agree with it, whether it makes sense. I know that there's a lot of folks devoted to Chevron in their practice. I don't know at this point how it affects my perception of agency discretion and how the agency will implement and the courts support it. But I do know that it does matter who's in the White House. And if the president doesn't want to regulate something, then I don't know. As we saw with President Bush's administration, the court disagreed with the use of Chevron. The Bush administration did not want to regulate greenhouse gases. And the court said, no, we think it's clear. We think you got to at least, figure out what the problem is, if there's a reasonable cause to regulate it. So again, I don't know at this point. I think that it really depends. But I defer to James and Margaret if they want to talk about it further.
Well, I think we are waiting to see. I mean, how much does every regulatory action depend on Chevron deference? Really, it's tied to the legislative language. And as someone who used to write legislation, yes, sometimes you're a little vague, and sometimes you're very specific. And so nobody's perfect. Drafting is never perfect. On the other hand, there's plain meaning. And I do think that there will be a working of this out. I'm not, it does make me a little nervous, of course, as it would anyone who's used to working in the federal government. because some of these issues are quite scientifically complex, as you just saw today. And so sorting through those, that information puts a lot more work on the agencies, on the plaintiffs, and any participant in a litigation. So that's the extra work part that is very concerning, which will end up, I think, creating a more confusing regulatory landscape than actually addressing this right head on. And so I think that my sense is that federal agencies have seen this coming and are starting to not rely on Chevron. I mean, and so and to the question in the chat about whether we shared this report with agencies, we did, and we presented it and have asked for feedback, and that invitation is open. They're very busy right now as negotiating the plastic treaty, so they asked for some time, but definitely willing to take more information on these questions and some of the questions in the chat that go to the CEQ activities.
And I will say, as reading a lot of proposed regulations nowadays, I mean, you don't see a lot of Chevron citations in those proposals. They're referring to the plain language of the statute. They're trying to ground it in the text. We'll see. I think a lot of the implications of this will be on the litigation front, as well as cautiousness around things to be proposed. But there are some of these laws that are really capacious in the way that they're drafted. I mean, the Clean Water Act definition of pollutant is extremely broad, contains, it's a really long list. It's worth looking at. And so pollutants, things being put into the water, including even heat, are covered. So it would be a tough argument to make that something like plastic is not covered by that kind of definition. But in other cases where things are a little less clear, maybe we'll see more cautiousness going forward.
Great. And this might be kind of a shorter answer, and I understand that there is some confusion about the difference between like microplastic regulation and then the chemical regulation. And someone's asking, is it legally possible to regulate microplastic waste as a hazard via, the Clean Air Act or Clean Water Act, Safe Drinking Water Act? And they're asking without upstream implications. I'm assuming that's towards the beginning of, the production side of things. So could somebody maybe speak to that?
I can just mention the difference between plastic and other materials is waste is regulated pursuant to its characteristics in our historical view of waste. But plastic doesn't exhibit those characteristics. And but as it fractures into smaller and smaller particles, then the material is almost like a precursor. It's like tetrachloroethylene if you're looking at trichloroethylene risk. It is a thing that would it degrade, then it could be characteristic. The smaller the particle, the more it leaches. And I don't know, at some point, perhaps it could leach and exceed the TCLP, SPLP, RCRA hazard characterization. But for if it has additives that are on the list. But we define hazardous waste so narrowly. It's such a narrow definition, really. It doesn't have these, these amazing properties that are so dangerous, like ignitability, reactivity, corrosivity. If it's merely toxic, that's just one of the characteristics. But I think what we would probably be, there are two routes I can see. One is if you're managing the plastic in such a way as to know to generate microplastic, then the microplastic could be considered as for its own added addition to the risk calculation for either particulate matter or hazardous air pollutant, but not the plastic itself. Now, what we see though, as we've seen, with the Superfund program and the new RCRA regulations back in the 1980s when they were new, is that the entities that failed to incorporate the cost of waste management into their business structure went bankrupt. That's all we cleaned up. Were all these bankrupt facilities that failed to include the cost of their hazardous waste, newly hazardous waste designated materials. Well, it will, if we regulate the end result of management of plastic, then it will have an upstream effect. It will cause people to be more worried about, people meaning, corporations, more worried about their material risk profile. And I think that it would have a chilling effect on entry into the market, and the use of plastic materials, packaging, James, and all the other types of materials that are really only used because there is no downside. If there is a downside, then it would be easier to transition into something else. So that's a long answer, but plastic isn't hazardous. Microplastic is not really necessarily hazardous. It depends on the material, and it's a degradation or downstream product.
Thank you. Is something else that I think is really imperative to this conversation. Somebody asked, shouldn't the physical and chemical components of the potential harms be figured out by companies and approved by regulators before they're put into the marketplace? Can we talk a little bit about our regulatory structure?
So we know, and Margaret and James can speak to this too, but under TSCA, that's our program, the TSCA Substances Control Act. Plastic is, there's a polymer exemption because of the molecular weight, because it's inert. But also, in talking about upstream, we have an entire industry of polymer manufacturers, and a lot of students getting their PhD, delivering their PhD dissertations on the new polymer they're going to create that's unique and all this kind of stuff. But there's never consideration at that stage of what's going to happen, what's the ultimate fate of this material. It's not considered in the patenting. It's not an element of the patent law, and it's not something, if it's actually a polymer and molecular weight causes it to be exempt, then that plastic material isn't, it's a solid material. It's not a chemical that's regulated under TSCA. And then there is an additive exclusion as well. Okay, Lynn Bergeson will tell me if I'm saying it right, exclusion or exemption, but additives are not chemically reacting with the material, so they're also not covered. They're just sort of added into the polymer matrix. So the one police barricade, the checkpoint is not working for plastic.
Well, the Minderoo-Monaco report was quite adamant that the balance of information is not adequate to the problem. And so that's why you're seeing a lot of calls for transparency and information, because we don't, even those companies purchasing the plastic to make into products don't know what is in the plastic they're using. And so this is a supply chain problem and a regulatory problem, both. And so to the point of how do we get ahead of this? Well, we're not ahead of it, of course, we're not. But how can we try and address that question, which is starting to at least say, in this type of product, we do not want this thing. But if you don't know what is even in the plastic polymer mixture that you're using, it's very difficult. FDA can, for certain kinds of uses, review what's in these materials, but then it can't be shared. So there's a lot of secrecy and confidentiality around it. This is a big topic at the treaty. That's super important because otherwise you're unable to use the tools that you could employ. So I would just say that. And right, our system is not built for precaution. And the other thing the Minderoo-Monaco Commission report author said is we're conducting an experiment on people. And what's going to clean this up? Liability.
Yeah, exactly. Yeah. And, as Margaret was mentioning, the rest of the world looking at chemicals of concern and polymers of concern and products that shouldn't exist and uses that shouldn't exist. Maybe in the United States, we'll still be an insular nation and we'll have a closed, use of these materials, but we won't be able to ship it outside our borders. I think that what will happen with Basel is it become more strict and more specific. The Basel, Stockholm, Rotterdam structure will cause us to not be able to export anything. We are now. We're exporting a lot of hazard, a lot of solid waste, a lot of plastic for recovery to nations that can't recover it still. And yeah, I think we're gonna find that we just have no place to go with this material.
Thank you all. I realize that we're at time. Sarah, can I kick it back to you for our closeout?
There we go. Yeah, thank you so much, everyone. We have like 36 more questions in the chat that we couldn't even get to. So we really appreciate all of your enthusiasm for sticking with us for the last 90 minutes, and especially to you, Mary, Ellen, James, Margaret, and especially Cecilia, for all of your energy and enthusiasm for this topic. Make sure to check out the webpage. It has a lot of links to reports and all of the litigation, all of this good stuff that you can dive into more after this. And we'll have the recording up in a few business days as well if you came late or couldn't stay the whole time. And we hope to see all of you at future programming. You can find that at eli.org. And thank you to Monterey Bay Aquarium again for co-sponsoring this with us. And have a great day, everyone. Thank you all. Bye.